In the matter 22 CF 240, State of Wisconsin versus Alberta Martin. The state appears through Assistant District Attorney Kevin Schmidt in person. We have Eugene Harrington, Defense Counsel in person. Ms. Martin appears by video conferencing in custody at the at the Bayfield County Jail. We're set today in this matter for a bond modification request. The court has reviewed the motion submitted. Mr. Harrington, you may continue and argue.
Your Honor, I think the court should have a conversation with Ms. Martin first. If I understand the conclusion of our telephone conversation last night, she no longer wants me to represent her, I think is what the
all right, I can ask her, and I can let you know though, Ms. Martin, that it's not your choice if you get to fire or ask Mr. Harrington not to continue. That would be my choice, and it's based upon certain factors, and you would have to produce certain information and evidence and testimony for me to weigh to determine if the court would grant your request to have a different attorney. Ms. Martin, is that accurate? Is Mr. Harrington, his statement about perhaps you wanting a different attorney accurate?
Yes, I did tell him that.
Okay. Now, is that what you want? You're looking for the court to listen to you to determine whether or not I will grant your request, or are you satisfied with Mr. Harrington and want to proceed?
Well, he doesn't represent me the way that he should represent somebody as a public defender, a lawyer.
Oh, how do you know? Did you go to law school?
Well, no, but you know, I've been in the system for quite a long time to know.
Oh, so you have the system knowledge. So now tell me though, I need to know, because again, I have to look at certain things, such as I have to look at your complaints, what they exactly are, the timeliness of them, how close are we to any type of hearing or resolution or trial in your matter. I also have to look at, you know, what this type of conflict may be and determine whether or not it results in what's called a total lack of communication, which would prevent an adequate defense. And we're talking an adequate defense. Is he doing his job effectively? The law says look at ineffective, but again, there's plenty of case law there. Court of Appeals makes it very clear as what is ineffective or not. And does this conflict frustrate your ability to have a fair presentation of your case to the court and to a jury? So what are your issues?
Well, I brought up a couple things that I wanted to present him before you. Without him even, you know, writing it down, he always just gave me a quick answer, a negative answer to give, you know, that he gave me.
Oh, you didn't like his response to something you requested?
That was negative. He said, I don't know if he's trained you in or what, but he also threw that in there, you know. I said, I know she's going to deny it. Well, how does he know that? Just because he trained you in there? That's what he told me he trained you in. Well,
he, for the record, yes. Mr. Harrington, I'm going to tell you, I was an attorney in front of him. Ooh. He was a strong judge. He nipped and he picked, but yes, but he was fair. Now he's a public defender, or no, and then I became a judge and he was my mentor judge, yes, for the first year. Then he retired. Now he's practicing in front of me. Now I'm just as hard on him as he was on me.
Yeah.
If I may, Your Honor.
You may.
Understand.
We had a conversation, Ms. Martin and I had a conversation last evening. She asked me about the petition for bail modification. I gave her my estimate as to what the court would do with it, and I told her why. And she said, you're being too negative. And then she said, well, how about getting me back to Burnett County so that I can bail out down there? And I was about to explain to her that the Burnett County Jail is being remodeled in construction process and that they had shipped all of their females out. And that's when she told me I was too negative and that I wasn't representing her, and she hung up. And that's why I brought this up to the court. Quite frankly, Judge, the impression I got from her was that she views it is my privilege to represent her And that's not how I view this.
And that is not even accurate or correct. The fact that you have a public defender appointed to you does not mean you get to decide that you don't like a public defender. You don't get a choice of attorney because you get an attorney to be appointed to you. That's what the law is. Not a choice of an attorney, not an attorney that's going to give you rainbows and butterflies. You have a very experienced lawyer in front of you, or who was representing you. A very experienced lawyer who knows the law inside and out, and he does for all intents and purposes. He may have an inside track as to probably how I think, not only because he mentored me for a year or whatever it was my first year, but the fact that he sits in front of me for the last 4 years, and he's practiced in front of me. And any attorney who sits in front of me can probably get an idea of where I'm going to go and what I'm going to do. I'm very clear, I'm very blunt, I'm very open. And you don't have the right to choose your attorney, but I'm going to say that I am going to grant the request, and I'm going to remove Mr. Harrington from the case, not because I feel that you've met your burden as to the factors, but because, quite honestly, I'm going to let him move on and use his services to somebody else who may need his services. So at this time, the court is going to remove Mr. Harrington from your case. You need to reapply to the public defender's office, and then they'll hopefully get an attorney appointed to you soon. We are set for a status on October 5th at 9 o'clock. And then, so hopefully you'll have an attorney appointed to you by then. As to the bond modification, he is correct. I'm denying it. There's no new information. You failed to come to court 3 times. And that's the whole purpose of bail, is to assure your appearance. And the fact that you cannot appear even by video is appalling. And so I'm leaving the bail set at what it is. You're going to apply for a new public defender. They will get one appointed to your case. Thank you. We are adjourned.